Welcome to ThePrint. Here's a story for you. In 2011, photographer David Slater happened to leave his camera unattended for a little while at a wildlife reserve. Taking advantage of the situation, 7-year-old crested macaque monkey, whose name was Naruto, took the opportunity and took several photos of himself. One such photo that you can see on your screens right now, it's stunning. You can see a close-up of Naruto's face with him looking like almost in a state of bliss, and a blurry background went viral. It became so famous, in fact, that Slater happened to sell the photo to Daily Mail, also used it in his own personal book. But that's when things got a little hairy, because the question of who actually owns the copyright of this photo came to the fore. Could Naruto own the copyright for this photo? PETA wanted it to own the copyright, but one of the courts in the US ruled that Naruto couldn't do so because a copyright can only be claimed by a human. But on the other hand, in another related case, another court also ruled that neither Naruto nor Slater could own this copyright, and so this photo, this stunning image that you can see again on your screens right now, remains in the public domain and anybody can use it without Slater's permission. Why I'm telling you this story is because this case has since raised several questions on who actually owns the intellectual property in a work that may not have been created by a human, and that's a very real question right now with the advancement in technologies and with transformative technologies literally revolutionizing the way we interact with each other and with the way we see the world around us. Because of course with great developments come complex challenges, and these are some of the challenges that we'll be talking about in today's episode of Laws of the Land, vis-a-vis intellectual property rights. For this episode, you have me, Apoorva, Mandhani. We have with us Bhadra, Sinha, and we have with us Supreme Court and Delhi High Court lawyer J Sai Deepak, who's one of core practice areas is intellectual property laws. Thank you so much for joining us, Sai.
Happy to.
Thank you so much for joining today for this episode, Sai. So, Apoorva has given, I think, a very interesting background to today's episode. So, let's talk about India. I mean, all of us know that this regime of intellectual property rights has been there around for a very long time, and it's a vast domain. So, for the benefit of your viewers, can you just first briefly explain this regime and what are the kind of laws that get covered under this regime?
So, one of the earliest patents to be granted in Bharat was for the pankha pulling machine.
Okay.
It was in the 1800s, and if I'm not wrong, this was in 1857. Okay. And this was to a particular gentleman by the name Depenning, after whom there's a firm in Chennai called Depenning and Depenning. Okay. So, contrary to popular perception, intellectual property regime, so to speak, has been in this country for at least a century and more, at the very least, at least since the First War of Independence. Previously, it used to be granted by way of letters patents or grants from the king, so to speak, or the crown. Let's call it the crown. Let's keep it gender neutral. Subsequently, with time, what has happened is certain rights which evolved thanks to their own, let's say, tradition, were codified statutorily. And India being India, we typically imported those legislations from the UK. So the legislation would first get promulgated in the UK, and then a few years down the line, it would get enacted in this country. The earliest, of course, being copyright preceding patents, to the best of my knowledge, or maybe almost simultaneous. The earliest Patents Act in terms of a statutory recognition that we've had in terms of a flesh and body act is the 1910 Act, which was the 1911 rather.
So this was the pre-independence era then?
Pre-independence. Okay. So both for patents and designs. Trademarks has always been the subject of common law, and with time it was codified. So there are certain species of IP rights which have had a common law antecedent and then subsequently codified. Some of them have had a basis in statute or in a let's say in a state grant, so to speak. Okay. Common law is something that has evolved on its own as a consequence of commercial practice. Okay, something that does not have a statutory basis. So yes, IP has been around in this country for a very long time. Now, it so happens that around 1956 is when we constituted what is known as the Justice Rajagopal Iyengar Committee, to basically ask ourselves, how do we use the concept of patents to drive innovation, to secure public interest, and also to ensure that there is foreign investment. So you're looking at multiple stakeholders trying to be, let's say, appeased in a very rational way. So that committee's report ultimately, so first it was the Bakshi Tekchand committee report, from there it becomes Justice Rajagopal Iyengar committee report, and then that becomes the basis for the current law, which you know as the Patents Act of 1970. So broadly, what is the funda behind IP? It is ek haath de, ek haath le, which is you give something to the society in return, you get something. Okay, which is, assume for a moment like, let's take the example of Coke. The recipe for Coke is protected by way of a trade secret. Now, the only person who benefits from the existence of a trade secret is the owner of the trade secret. Except for you consuming the product, you don't get to know what is inside the product, what makes the product so special. Now, the problem with it is that the amount of knowledge in public domain goes down with the hoarding of trade secrets. So you needed to strike a balance, and that balance is called broadly the IP bargain or the patent quid pro quo, so to speak, which is you will get a specific form of crystallized strong right for a limited period of time. It is a monopoly, so to speak, in return for disclosing that knowledge in public domain. This is the patent bargain, this is the IP bargain. Now, the grant of a monopoly by definition is anti-competitive, right? And still you deem it fit to grant a monopoly in public interest. So what is the logic here? If both of you were competing in the same market and you had the same products to offer or similar products to offer, and there is no technical difference or technological difference between the two of you, what is it that you're fighting each other on? Price point, profit margin, so on and so forth.
Right.
Now that means both of you will only find ways to reduce your manufacturing costs, so on and so forth. But the quality of the product is never going to change. So as the consumer, I don't get to see a better quality of product, so the options are less. So this kind of a fight is called static competition, where the product remains the same, but the fight is on the price point. Intellectual property introduces what's called as dynamic competition, which means the options keep changing. And the fight is about who can provide a better product. And whoever does that needs to be rewarded in some way because he's pushing the envelope when it comes to innovation in that particular sector. So patents, intellectual property broadly are meant to achieve this. So anybody who wants to play catch up as a competitor to this particular person has to do better. It can't just be about the price anymore.
So are you trying to say that this entire regime was brought in for the benefit of the public per se?
So ultimately the target is to provide better options to the public. So I would call this a quadrilateral equation where there are four stakeholders. The public to which this competition is geared towards, the competitors who are participants to this game, and within the competitors you have two sets of people, one who creates intellectual property, believes in innovation, and the other who doesn't have either the will or the resource to invest in innovation, but who's equally a competitor in that market. Because it's not necessary that two people who operate in the same market have the same degree of, let's say, power, so to speak, in terms of market power. Then, of course, comes the oversight or supervision, which is of the state. So all four have a role in this particular equation. Now, the different forms of intellectual property that we're looking at are...
that's what I was coming to,
Right.
because what you have so far spoken about is primarily innovations.
Right,
So
right.
what about the other creations, intangible assets that we have?
Right. So I'm happy that you've used the word called intangible assets because that broadly is what characterizes intellectual property. So you're looking at patents, copyrights, trademarks, trade secrets continue to be a form of this, geographical indications, semiconductor design layout, and plant variety protection. These are the broad forms of it. Broadly, all of them reward original thinking if I were to distill it to its most fundamental form. Now, it could be original thinking by way of coining a unique trademark. Sony has no meaning to it.
Yeah,
Right?
but that's okay.
That's one. Or use of Apple for a computer. So the word in itself may not have a specific meaning to, let's say it's not coined, but in conjunction with electronics, it makes a difference. But if you were to use Apple for Apple, then there's a problem,
Okay.
right? Then you look at semiconductor design layout, that is for the design of the chip.
Okay.
Then for plant variety protection for plant breeders, geographical indication for basmati rice, Kanchipuram saris, Kondapalli toys, so on and so forth, or Bidri silver work, right? So geographical indications is typically used even for champagne. Not everybody can call it champagne. Not everybody can call it Scotch whiskey. Not everybody can call it, let's say, tweed jacket. Because there's a specific contribution that can be traced to a particular geography. Hence, geographical indication. So you can actually grow basmati rice across the country wherever, let's say, agroclimatic conditions are suitable. But not everybody gets to call it basmati because it is meant to be traced to a particular geography. So what is the difference in the market? Those who get to call it basmati, they sell it at 1,500 bucks per quintal or ton, and those who don't, 3 times less. That's the difference.
Okay, so another area which I would like you to talk on is about, which is often debated, is, it's often contested in the courts, is about copyright in academics.
Right.
There is always a tiff between, publishers who publish academic books and researchers who are researching in public universities. They kind of demand easy access or probably less cheaper access, to these books because they feel that it is their right to access knowledge. So how does the regime deal with this area?
So fortunately, Indian Parliament over the years, regardless of who's been in power, has struck a balance between the standard Indian expectation to get everything free of charge and the need to protect the rights of creators of intellectual wealth. You have to strike a balance between both. Neither is always fully right. The truth is always in between. So what these legislations try and do is to hand some kind of an incentive to someone who is invested in this, and also ensure that he doesn't charge for more than what he deserves. Okay, he doesn't extract more rent from the public. Okay. So there are several mechanisms in our legislations by way of what you call as compulsory licensing mechanisms. Or for instance, there are certain species of works called orphan works, where you don't know who the owner of the copyright is or the publisher has gone kaput, so on and so forth. So there's nobody to assert anything on that. So all these, let's say, circumstances which are in between the extremes, so to speak, all of them are addressed, by and large, of course. So the first thing that needs to be busted in the popular mind is that IP legislations are exclusively for IP owners, or they are some kind of protectionist legislations to protect one particular species of right owners. No, that's not the case. Every IP legislation balances the state's duty, consumer interest, the rights of competitors, and the rights of right owners or IP owners in that sense. And in fact, I'm happy to say this, that contrary to popular perception, Indian thinking when it comes to some of these subjects is way more advanced. Some of our judgments are cited in not just in South Africa, but also in certain parts of either sides of the Atlantic. Okay, not that I draw any particular pride from it. It's not a badge of honor. I'm just saying that. So it's not as if we constantly look up to other jurisdictions to draw inspiration. In the realm of intersection between free speech and intellectual property, there's a fantastic case. Whenever you want to, you should read. It's Tata Sons versus Greenpeace, where Greenpeace was basically contesting, or it had a problem with the port being built in Bhadra, because that happens to be the nesting ground for olive ridley turtles. So Tata sued them for 1 million. Oh no, not 1 million, sorry, 10 crores. Okay, before the Delhi High Court. So the court, and they did so because Greenpeace came out of the game called Tata versus Turtles, where it was a rip-off from the Pac-Man game. So the Tata logo was used for the devil there, which was going about eating the olive ridley turtles. It was very creative in that sense. So Tata, among other things, apart from defamation, also sued for trademark infringement because the trademark was used in a derogatory sense, according to them. So this effectively led to a fantastic judgment on what is the trade-off between constitutionally guaranteed fundamental free speech rights and intellectual property rights. This judgment drew significantly from certain South African judgments and then was subsequently quoted in other jurisdictions. So we have contributed to such things. So the sum and substance of it is, I think, nobody should assume that intellectual property legislations give a walkover to IP right owners. Public interest is seriously protected, particularly in critical realms such as pharmaceuticals, agrochemicals, food substances, chemical substances. That's one of the reasons that we waited until 2005 before product patents could be granted in these sensitive areas. We were among the last countries to do it.
So, in today's time, can a researcher get a photocopied book of an academic work?
That's a very good question. See, it's like this. If you were to, let's say, photocopy a few pages, and by a few pages, I hope it's in single digits. Because you see, sometimes it so happens that a book may sell not for the entire book, but because of a particular chapter. And if that's the entire chapter that you wish to photocopy, you're taking away the mojo of the book. Okay, that can't happen. Okay. And so what has happened is, over the years, even publishers themselves have come out with middle path options, via media, so to speak, which is, let's create something called as the Indian Reprographics Rights Association, which allows people to photocopy at a certain price. You will obviously be paying more than the amount that you'd pay to a standard photocopier, but you're also making sure that the person who's created the work is benefited in some way. Otherwise, what stops people from simply cannibalizing stuff from 10 different books and creating a new book out of it?
Okay.
Then you're effectively infringing 10 different people and 10 different rights.
I get the understanding that what we're talking about here is also maybe something called fair use or the exceptions that we're talking about.
Correct.
Could you tell our viewers a little bit about that in all the laws that maybe you've spoken? What is not a violation?
So the thing is, fair use is typically used in the context of copyrights and trademarks.
Right.
And there are non-infringing exceptions when it comes to patents, designs, and other places. Okay. So what are you effectively looking at? The principle is that use of an IP protected work which does not eat into a legitimate revenue stream of the right owner would be fair use. So for instance, if there is a market for creation of photocopied course packs, and that becomes a legitimate stream of revenue. Why? Because academic books are very expensive. So no academic publisher expects every student to have a copy of it. So libraries and establishments have copies of the book, but students go with photocopying. So therefore, the publisher says, I will sell a few books to the university and then I'll invest the rest of my resources in creating course packs for students. Okay. Now that's a legitimate revenue stream. Now, if you choose to actually photocopy several books and then sell it as, let's say, course packs, and a photocopier does it, it's eating into the revenue stream of the publisher. Right. So the test is simple. Is this a conceivable form or platform through which this book can be sold? So for instance, maybe let's say 10 years ago, nobody thought of an audiobook or an Audible. Today, you do. Now, sometimes I get a message from someone who's read a book who's basically saying, why don't I record this and I release it so that working people who don't have the time to sit and read can continue working and listening to it, right? Now that affects me, because today we are living in the age of an Audible. That means there's a legitimate revenue stream.
Right.
Now these days you have a lot of book reviewers who start a video on YouTube where portions of the book are read out in the name of review. Then that affects my revenue stream, right? So if something is conceivable as a legitimate form of use and you step into that particular territory, you're stepping into the territory of the person who is meant to make that money. That's how you define fair use, broadly speaking.
And also not personal use, like that's
of
where
course,
you're
see,
connecting.
let's say, so what is the question? You choose to do something primarily for your private consumption,
right?
Personal consumption. And there's a distinction in law between personal consumption and private consumption.
Okay.
Private has to be compared with public. Personal is usually related to that particular person, right? So research, all review, criticism, spoof, all of that is fair play or fair use, okay? But if you choose to create an audience out of it, you need not make money from it for it to constitute unfair use.
Okay.
The test is not whether you make money, the test is whether you're actually hurting the person who's supposed to be making money.
So commercial, whether it's being
commercial interest of the person who it belongs to must be affected. You need not make money. Because at the end of the day, what if your interest or your intention is to destroy my market and not make money out of it? It's equally bad for me. It is not, I don't derive any kind of salvation, let's say, I don't derive any kind of satisfaction from the fact that you have not made money. You have cost me money, that is enough. So fair use is typically defined on those terms from the perspective of the right owner, not from the perspective of the user.
Right.
So, Sai, you just spoke about, that our laws are sufficient enough to strike that right balance.
Right.
For between the rights of a innovator and the public interest. Right. So, how do you say that? What is there in these laws that is striking the right balance?
Okay. So, let's take an example of a critical sector. With respect to a powerful right, patent right, because it has the ability to stop a business. If you take away branding rights, the product is not stopped, only the brand is stopped. But if you enforce a patent, the product itself is stopped. And in some cases, some people may be manufacturing only that product. So I'll give that example. In the context of a pharmaceutical substance, if it is meant to be used for cancer, let's assume that the entity which has the right over that molecule chooses to make that drug scarce to simply artificially jack up the prices. or it chooses to limit its availability only to urban places, despite the condition being prevalent across the board. Most people assume that cancer is an urban disease. Obviously, it's not. Right? But most of these companies may or may not have distribution centers which go right into the rural center. So you have got a right, and that right has certain expectations that you will fulfill public requirements with respect to this product to the maximum extent possible. That's one of the working conditions under the Patents Act. Okay? But if you choose not to do so, if you're the right owner and she is your competitor, she can say, this person's not actually fulfilling his or her obligations. And there's a public need, crying need for the demand to be met.
Okay.
I will step into the shoes of this person and I'll do the job better.
Okay.
Now, obviously, I'm not asking it for free. I will give this person a reasonable royalty. Therefore, I move an application before the patent office saying, here is the evidence to basically show that this is the need, this is the delta between the supply and the demand. I wish to step into the picture. Please fix up a license rate and I'm happy to pay, and I will pay.
Okay.
So that is meant to cater to public interest. Right? So a right owner may have actually come out with a great product. But since it is meant for public consumption, it goes back to the fundamental patent bargain that you must actually put it to the maximum possible commercial use in the most affordable manner and accessible manner possible, so that the target audience has access to that particular product. Should you choose to fail, others step into the picture.
Okay. So does any one of these laws give the right to the public to go to the court
100%.
and agitate against this kind of monopoly?
100% it does. So when it comes to compulsory licensing, obviously only a person who can fulfill the obligations of the right owner can step in. So it is typically a competitor.
Okay.
But assume for a moment, I'll give you another example. You as an innovator, you get, let's say, clever by half, and you come out with a product X, and then you make X plus. X plus is merely a cosmetic change. In sum and substance, it's the same as X. When you file that application, what the patent office does is that before it grants the patent or before it actually starts examining it, it gives a public notice to people.
Okay.
Look, this fellow has filed this. This is what he intends to claim. Does anybody wish to challenge it? So a pre-grant opposition mechanism is provided for in these legislations. And anybody, it says any person, can come and say, I may not have anything to do with the industry directly, but as a member of the public, I believe that if you grant a right here, it encroaches into our interest. It impinges on our interest. And this person's taking you for a ride because he has not given anything that's worth the grant of a patent. So there are instances where any member of the public can take a shot at the right.
Okay.
There are instances where only members of the industry or who are on the peripheries of the industry can get into the picture, because then the battle gets technical.
Okay.
Right.
So, and there are instances where the state can suo moto revoke a patent in public interest or suspend it to say, you have not used it enough. Sorry, you're squatting on it, you don't deserve it.
So in some way or the other, the acts do cater to the public interest
Absolutely,
need.
yes.
Okay.
Without
It may
a
not be permitting any direct intervention from the public, but in
100%.
this manner it
the
does.
public certainly has the right to act as a prime mover in several instances
Okay.
to agitate its point of view. There are any number of instances where patient groups have come forward and participated in pre-grant oppositions, in revocations, and also to present their point of view in courts of law. There's a very popular case of Delhi University involving a photocopier, I think Ram Rameshwari, right? And in that, student groups who felt that the outcome would affect their interest were allowed participation from DU.
Okay. Okay.
Right.
I don't agree with the outcome,
Yeah.
but nobody can say that there is no avenue for public participation.
Okay.
That's there.
So, Sai, in IPR litigation, we get to hear a lot about cases that are contested over generic names.
Right.
By two different opposite parties. So can you just explain that a little bit for our viewers? What exactly is the
Right.
meaning of generic name and how is it contested?
So this is in the realm of trademarks.
Okay.
Okay. So broadly, what happens is the strongest form of a mark or the strongest trademark is that class of trademarks which are distinctive or which are coined, which are inventive. So they fall under two categories. Either by themselves they're great, or a generic word or a non-distinctive word being used in a radically different context. Somebody decides to make Infosys vests and briefs.
Okay. Okay.
Think of it on those lines.
Okay.
Okay. If somebody does it today, he's infringing the right of the original person because he's diluting the original brand.
I see.
But let's assume for a moment that it's as generic as it gets. Let's think of somebody says Darzi for tailors. Okay, seriously problematic.
I see.
Because what you're doing is that you're taking away certain words from common domain, appropriating it, and effectively an entire class of your competitors are deprived of the right to use this as a trademark. Now, in these instances, there are two rules broadly speaking. One, that is, it's like public property. Nobody owns it, and therefore everybody owns it. So generic names belong to everyone. It's in that sense, it's also common to the trade in some sense. Second is that you can add something plus Darzi, but you'll have rights only over that combination, but not Darzi alone.
Got it. Got it.
Darzi may feel, I'm not saying you can't use it as a trademark. Your claim of exclusivity is problematic.
Okay.
Okay, that's one.
Yeah.
Two, in certain instances, what happens is, take Naukri.com for matter, that's the exact opposite example. It's been around for such a long time, it has a reputation, so on and so forth. So in those instances, the absence of inherent distinctiveness in the mark is compensated for by recognition of the public. To say, now if you speak of Naukri, there is a memory recall which goes exclusively in one particular direction.
Yes.
If you're not able to prove this memory recall, or you don't need sufficient evidence to say, oh, public now knows you, sorry, you don't have a right over it.
Can you protect a part of a name as well?
Of course. So you have composite marks. Where composite marks, what happens is it could be two words. It could be two words plus a logo. So the question then would be that when you apply for it, did you make separate applications for each of the parts, or did you apply for the entire whole as a single? Now, usually when you apply for the entire whole as a single, then you get to only assert it as a whole.
Right.
You can't then say, ye iska bhag hai, so I'll apply it separately. I'll enforce it separately. That won't work. Now, especially if it happens to be, let's say you have a beautiful logo and you say sum plus Darzi and you get the entire thing registered. But when you choose to assert it against a third party, what you're asserting is only Darzi. Then there's a problem.
Right.
Of course, there are multiple qualifiers here, but this is the broad example.
Got it.
Okay, so just taking the discussion now to, since we've been mentioning innovators and innovation, does the law, and this is a very general question, but in light of a recent Delhi High Court judgment which sort of spoke about this, does the law in its current form, has it caught up with these innovations, especially the technological advances that we are seeing, say when it comes to artificial intelligence?
Right.
And then we'll probably come to a more specific question as to if we're talking about AI and AI makes something, say an intangible asset that we spoke about or a creative work. Can it register, I mean, can it be registered as, can it be patented, can it be protected?
Right. I'm not sure AI still is better off than the monkey. At least in the eyes of the law.
Right.
Okay, I'll come to that in a detailed fashion. But the first response is, see, I think so far, broadly, the high-tech industry has not agitated the inadequacy of the law from the perspective of protection.
Right.
However, there are certain legitimate questions or concerns with respect to how it's being interpreted. And what are we specifically talking about? Computer programs.
Right.
So what we have taken as a position in India is that computer programs, we use the word per se cannot be protected.
Right.
So the question is, when you say per se cannot be protected, what should it have for it to actually cross that barrier? So broadly what we have said is, the computer program must be used in such a way that it causes a technical effect. Which is to say, assume for a moment that a better program leads to a better functioning of the camera. There are multiple tests which have been evolved in US, EU and India, and we are closer to the EU position than to the US position. I'm not saying India doesn't have its own independent position, but in terms of proximity, this is where we stand. Now, therefore, the question would be, in what contexts can a computer program satisfy this particular threshold? Today, one of my juniors actually showed me a very interesting application. A bunch of economic policy commentators have filed a patent application for an economic model.
Oh, okay.
And we first of all, it's not possible, but it shows to the extent to which people are thinking of patents.
Yes.
Right or wrong is a different issue, but the IP bug has bitten. Okay. Now, I would say, I understand where this question is coming from. The observation of the Delhi High Court, I think, is spot on, because I think there needs to be some policy clarity in terms of what should the AI industry or the software industry or the computer program industry expect when we are increasingly dependent on Internet of Things and whatnot. So there are multiple areas where innovation is triggered by a better software or whatnot. So what should be done there? That's a legitimate question.
Right.
Now the second thing on the question of ownership of any output from AI itself. The law recognizes a human being as the prime mover. Now had it said a sentient being, you could still go back to AI.
Okay.
Right.
So we are looking at human beings, and secondly, even a minor can be a right owner,
Okay.
but the right will be held in the name of I suspect, because the law doesn't permit a minor to enter into contracts, right? So perhaps I think the guardian gets the rights for it. AI, as far as I am concerned, is not part of this definition, unless you say that I instructed this AI to do something and I've commissioned this. So the AI is treated as your non-human employee, and therefore it may be the author, but even then the author cannot be a non-natural person. So you would be seen as the vicarious author as well as the vicarious owner. Both.
But that's an interpretation that could come.
I'm playing around with it.
Okay.
No, but do you think that the law requires amendments and modification, considering that we are having so many, AI-related
Without a doubt,
innovations
because you
happening?
see, life moves faster than law, and technology certainly moves faster than law, and law is always forced to play catch up. That's always the case. And I think it's good to have a revisitation every few years, and this is, I think, a great juncture because we are poised from the startup perspective to actually go to a different level.
Yeah.
And a lot of the startup initiative is centered around AI, so on and so forth, blockchain, as you mentioned before. So I certainly believe that we may want to take a look at a policy relook for a very different reason.
Okay.
Until the 90s and even early 2000s, India was doing it from a defensive perspective.
Okay.
Now today you've arrived at a place where you're looking at it from a protectionist perspective because you want to protect your own industry.
Right.
Until then, you were trying to cater to just public interest from what you thought was the MNC onslaught. Rightly so.
Okay.
But now you're the one who is creating MNCs. You have these options here. So you have to protect public interest and also revisit the law in such a way that it provides impetus to the homegrown industry. And how do you then also strike a balance in terms of protecting it against competition? Sensitive concerns there.
With this, we've reached the end of this episode. In this episode, we spoke about intellectual property rights. As I pointed out, they've been the rights per se have been in existence for maybe a century now, but it seems like it's time for the law to stop playing catch up, but take a relook at the advancements in technologies or the changing times. Thank you so much for watching this episode. I hope you enjoyed it. Do let us know in the comments section, and please follow us on Twitter, Instagram, and Facebook.